Wouldn't it be great? In fact, I think it'd be great if we had a system in the UK whereby if the general public en masse felt that a prison sentence was way too harsh, they could petition for it to be reviewed, either by the Criminal Cases Review Commission or indeed by the Court of Appeal. And for that matter, while we're at it, whether or not you should have any say in why we should allow asylum seekers to stay in this country. More about that in the second half of the video, but let's talk about these sentences being unduly harsh first. Now, you might ask, well, how about unduly lenient? Well, we do have a system for that. We have a system whereby you can ask for a Crown Court sentence to be reviewed if you think it's too low. I've done this myself, and not to say that it was my request that resulted in the sentence being changed, but the sentence in that particular case was indeed changed. It was increased quite considerably. But you cannot ask for a sentence to be reviewed if it's too harsh. Now, judging by recent news reports, for example, our current Attorney General, Lord Hermer, declining to review unduly lenient sentences given to a rapist, a paedophile, and a terrorist fundraiser, each of whom received a sentence lighter than that of Lucy Connolly, this does bring into question whether or not this system is actually working. But now bring in Richard Tice's 10-minute bill, introduced into Parliament today, which I'll play a very snippet for you in a minute. Now, bearing in mind it's a 10-minute bill, only 60-odd or so have actually made it to law since about 1945, this could make history. And it's being dubbed Lucy's Bill. Obviously, as a result of Lucy Connolly, you'll be familiar with the news just recently with Richard Tice visiting Lucy Connolly with complaints made against the prison and how she's been treated there. But just take a very brief listen to what Richard Tice has to say about this 10-minute bill here, and then we'll talk about what that might mean. Take a listen to this.
Thank you, Mr. Speaker. I beg to move that leave be given in this House to bring in a bill to make provision for the general public to require and petition that the Criminal Cases Review Commission should review cases where the petitioners believe that sentences handed down are either too lenient or too harsh, and to make provision also for the review of such sentences and to make provision for the referral of such cases by the Commission to the Court of Appeal or the Supreme Court.
And I'll link this from the Daily Express below so you can listen to the full thing. It's very much worth listening to. As I say, I think that we could be in a position of making law here, making historic law where the general public of the United Kingdom have some sort of say whether a sentence is too harsh or too lenient. Because I don't think it's venturing too far into opinion from my channel here to say that there are a vast number of people that do think this sentence for Lucy Connolly is simply way too harsh, even though the Court of Appeal has already said that it was in line with the sentencing guidelines and so on. I've made my views about those known in the past. But at the moment, all you can do is this. If you think a sentence is too low, you can ask the Attorney General's office to review this and decide whether or not this gets a full review sent to the Court of Appeal. So first of all, let me know in the comments whether you think that is a good idea, whether you would make use of such a system and have your voice directly heard as part of a petition to have either the Criminal Cases Review Commission or the Court of Appeal or even the Supreme Court have a look at the decision, and of course how you might think that might affect your confidence in the justice system. Richard Tice says that this bill would provide a democratic safeguard against overzealous two-tier justice imposed against particular individuals, especially who have effectively become political prisoners. He says the general public would be able to act as some sort of backstop if a sentence is patently too lenient relative to the crime or patently too harsh relative to the crime. So let's look for a moment at those sentences that were not referred to the Court of Appeal for being unduly lenient and just left as is. They include the following. One individual who was given a 28-month sentence for raping a woman in her own home. Another who escaped jail entirely after pleading guilty for attempting to incite a 13-year-old girl to engage in sexual activity. And a third who was actively participating in raising funds for a terrorist organisation, also escaped jail, getting only a 3-year community order. Now, bearing in mind Lucy Connolly was given a 2.5-year prison sentence for a single tweet that I would say most of us agree she shouldn't have sent and was a wrong thing to do. I say most of us because one or two people in the comments have said they don't agree with that, and that's entirely down to them. I think she shouldn't have sent it, and I think most people would say she shouldn't have sent it, and it was a horrible message and so on. But nonetheless, she pleaded guilty when I think perhaps she should have pleaded not guilty and gone to trial. But she was given a 2.5-year sentence in comparison to these others. So let me know in the comments whether you think Richard Tice is really onto something here to really revolutionize our legal system and give the general public some confidence that they can have a say in whether they think a sentence is unduly harsh or indeed unduly lenient. Because at the moment, it must go through the Attorney General's office, and many of those, as you've seen reported, are not referred to the Court of Appeal for review, and they are left as is. This bill, albeit a 10-minute bill, some 10-minute bills do make it to law, and this could make history. If Lucy's bill were to make it to law, it would give you, the general public, a say in what happens in these sentences. Just as an aside, we hear about data leaks all the time, but what really happens with that data? Well, the data invariably ends up on servers scooped up by marketers, and then they use that to market information to you, and ultimately it might end up on the dark web. Now, one way that you can get rid of that is with a partner of mine called Incogni, who will contact all of these data brokers and marketers and use UK and US law to require that they remove your data from their servers, thus lowering the risk of identity theft. It is a done-for-you service. You get access to a dashboard that shows you the progress they make when they contact these companies and they demand that they remove your data from their servers. And because they're a partner to my channel, you get 60% off the annual plan using the code BlackBelt on screen and in the description below. You can visit incogni.com/blackbelt, use that code, and you'll get 60% off the annual plan. So thank you to Incogni for sponsoring this video and for keeping you all safe. Now, speaking of stories that don't seem to make sense, often you get headlines like this one where you might think to yourself, that surely can't be right. And again, the public should really have some kind of say in this. Now, this headline, as it sounds, migrant can stay in the UK because he doesn't want to shave. The Telegraph reports an asylum seeker from Tajikistan has been allowed to stay in the UK because he would have had to shave off his beard if he was deported. He's an unnamed, I think there's an anonymity order attached to it, come back to that in a minute. He won an appeal arguing that he could be tortured and have his facial hair forcibly removed if he went back home. Now, this, I will warn within this, there is a warning here to say no one shall publish or reveal any information, including the name or address of the appellant, likely to lead members of the public to identify him. Failure to comply could amount to contempt of court. So if anyone has any idea who this is, keep it to yourself. There's your warning from this here. But as you can see, this was in the upper tribunal in the Immigration Asylum Chamber, and reads as follows. It says that the judge at first instant accepted that the claim was based on convention reasons, namely the religious belief that imputes young men with beards. He concluded at paragraph 39 that the appellant had a characteristic that could cause him to fear persecution. Again, his beard and the religious belief that it was said to express. The tribunal said that is a significant finding in the appellant's favour, as once the judge determined that he has a genuine subjective fear of being persecuted, it became necessary to establish whether that fear was objectively well-founded. However, then the tribunal noted that at paragraph 45 of the original decision, the judge took issue with whether or not the appellant would remove his beard on return, and the appellant complained that the judge failed to note that although he said he would shave off his beard himself and thus remove his own risk upon return, he would only do so because if he sent back, he said he would have no option but to shave it off. The tribunal said that if he wears a beard out of religious conviction but will conform for reasons of securing his safety, he may be entitled to international protection. Ultimately, the tribunal found that the original judge failed to consider the objective risk to this appellant by reference to background material, saying that Mr. Bazzini took the tribunal to several examples in the appellant's bundle which pointed to torture and mistreatment remaining widespread. Arbitrary arrest being commonplace, thousands of Tajik men having their beards forcibly shaved and being fingerprinted and recorded by the authorities. Thus, the tribunal said these examples of background material before the judge were relevant to and should have informed his assessment of whether the appellant was at risk on return, as well as the likelihood and whether the appellant would feel compelled to shave due to fear. but they make no mention of that in the decision. So in light of all that, the upper tribunal has sent this back to the first tier tribunal for a fresh hearing on all of the other issues, having set this decision aside. Now, the Telegraph gives further insight into this and said in Tajikistan, beards are unofficially banned by the government and hundreds of thousands of men have been arrested for having one in the last decade. Men in the country with beards are arrested, shaved against their will, and have their fingerprints taken by police. It's part of a government campaign to try to prevent men from becoming radicalized and joining Islamic extremist terror groups. And so this, they say, ministers are proposing to raise the threshold, making it harder for judges to grant the right to remain in the UK based on Article 8 of ECHR, which protects the right to a family life, and Article 3, which protects against torture, inhumane or degrading treatment. So this again brings into question what the general public think about these decisions and whether there is or could be or should be any say by the general public in how these things are applied. One thing I can say is that when an individual or a company or an organisation takes a case seriously and takes it to court, as in For Women Scotland going to the Supreme Court on the issue of biology and sex, we do get outcomes which ultimately have a massive effect across the country. For example, the recent update by the UK Parliament regarding toilets and changing facilities. They now say that members of the public should use facilities that correspond to their biological sex or gender-neutral toilets. And also, we have an update in the Equal Treatment Bench book for judges, whereby the treatment of trans people in court, for example, rapists that have been wanting to be identified by the female pronoun, judges have now been given guidance on this. And there's a few paragraphs on this. Paragraph 17 says where one side's case hinges on the recognition of the biological sex of the trans person as crucial, and the other side on the recognition of their chosen identification, judges need to be careful not to let their choice of gendered pronouns give an appearance of bias or that there's a predetermined conclusion. If possible, using the individual's name instead of a pronoun where the pronouns are contested. Alternatively, the gender-neutral pronoun. They might help to minimise offence, etc. There will be other situations where the judge may decide not to use the trans person's preferred name or pronouns to ensure the witness can give the best evidence. For example, female rape victim might find it incomprehensible if the judge and others refer to her biologically male attacker as she. So some common sense prevails here. In the end, it says it is for the judge to ensure that the proper balance is struck between respecting how a trans person, as with any person, wishes to be addressed, and enabling a witness to give the best evidence in court. And obviously that makes perfect sense. And at 19, I'm very pleased to see this one. Witnesses should never be compelled to use the trans person preferred pronouns. It should always be permitted for them to refer to a person how they presently understand or previously knew them. As in any case, for example, fraud where a defendant has used multiple identities. A victim of domestic abuse, sexual violence, or assault by a trans person is particularly likely to describe a perpetrator in accordance with the victim's experience and perception of events. To do otherwise and place additional or artificial barriers on a witness is likely to detract from their ability to give the best evidence. So you can find all of these online. This is what I like about an open and transparent justice system. You can see these guides and what information and guidelines, etc., has been disseminated to the judiciary and so on. So I hope you found that useful. Please do like the video and subscribe. And as always, thank you for watching.